This is Texas A&M versus Doe, appeal number 1019-00057CV. You may proceed when ready, counsel.
Thank you, Your Honor. Doe has sued Texas A&M, claiming that its disciplinary hearing violates due process because the university does not allow a student's attorney to directly question adverse witnesses. Doe has failed to plead a viable due process claim for at least 3 reasons. First, Doe voluntarily refused to attend his hearing. This choice forecloses any claim arising from that hearing. Second, as every court to consider this question has held, the Due Process Clause does not require any attorney participation in university disciplinary hearings, let alone require universities to allow a student's attorney to directly question adverse witnesses. And third, Doe has not pleaded any facts that can show that he was prejudiced by the university's refusal to allow his attorney to question adverse witnesses, and he will never be able to plead such facts because he refused to attend his hearing and take advantage of the processes that were offered to him.
Even if Doe believes that he has been constitutionally violated and thus he decided not to attend, do you still take the position? Obviously you do, and why? And also, does it really constitute a waiver that he didn't attend? Because y'all are here basically on the original lawsuit with a plea to the jurisdiction, which has been denied by the 272nd. And then, as you well know, it may be that you ought to consider, and he ought to consider, your opponent, whether an amendment to the plea to the jurisdiction is in your future. Because waiver may just fit as an affirmative defense here, which smacks of summary judgment practice. Maybe not plea to the jurisdiction. So will you address it in that context, please?
Yes, Your Honor. Waiver is a prudential rule that courts apply. It's not an affirmative defense. And what all the federal courts have held, if you look to Carmody, the Seventh Circuit, it was a motion to dismiss. And just like this case, the plaintiff objected to certain procedures in the hearing. The university said, we hear your objection and we're not going to change our proceedings. The plaintiff refused to go forward, and the court held that you cannot raise a claim from that hearing, motion dismiss granted. As our Supreme Court has held, and as this court has held, if you cannot plead a viable claim, then the district court must grant the state's PTJ.
You don't get a shot at amendment?
Nothing that he can amend can change the fact that he skipped his hearing. Nothing that he can amend can change the fact that he waived his due process claim. And if I could address Your Honor's constitutional claim, anytime somebody raises a due process claim, they are raising a constitutional claim. And so it can't be the case that as long as you say due process, that you can get around waiver. As all the courts, we've cited multiple court decisions to this court that all have the same common sense rule. And that is that if a hearing provides the core protections of due process, notice and an opportunity to be heard, the plaintiff must take advantage of that process in order to challenge it. And that makes sense because our Supreme Court has said that courts do not establish categorical rules when it comes to due process.
Well, we must be assuming that he's, at the moment anyway, constitutionally as applied as opposed to some facial challenge. At least, I don't think so. Could be, maybe. There could be some fact issues lurking there that gets you, again, beyond plea to the jurisdiction, and that the trial court has an obligation, or at least a trier of fact, one way or the other, to address those things. You're absolutely sure you'll never get there?
Yes, Your Honor. The only facts that he could possibly allege, this would be a different case, is that he attended his hearing, he can point to what happened in that hearing, he used the processes, and he would able to come to court and say, look at what happened here. This was unfair. He can't do that here. So what he's asking the court to do, because he didn't do that, he's asking the court to establish a categorical rule that whenever there is a quasi-criminal disciplinary hearing, which would in fact be almost all disciplinary hearings, because anytime you have sexual violence, even we see from the UT and USC scandals that even cheating can be a federal crime, wire fraud fraud, for example, any university disciplinary hearing can be described as quasi-criminal if the facts would also be a crime. And so what plaintiff is asking for here is a categorical rule that whenever you have a quasi-criminal disciplinary hearing, that you have to allow counsel, no matter what the facts, and there's a credibility issue, you have to allow counsel to directly question adverse witnesses. The Supreme Court, our Supreme Court, in both Fan and Bexar County, said courts do not issue those sort of categorical rules. In Fan, the court found a due process violation, and it still refused to issue a categorical rule. And the reason is, Your Honor, it's important to understand what is not at issue here. What is not at issue is what is good policy. That is currently being debated in the legislature. They passed a law just last year, just this past term, to encourage reporting of campus sexual assaults. It's currently being debated in over 110,000 comments for the Department of Education rule that is interpreting Title IX. Under plaintiff's view, this is all a waste of time. Under plaintiff's view, the court will tell you that everything that DOE, all of this debate is all for naught because the floor is attorney cross-examination, something that no court has ever held, and that every court to consider it has said no. Because as our Supreme Court said in Fan, what courts should not do is impose formalized procedural requirements on university disciplinary hearings.
What's going to happen if the Department of Energy, the federal department,
That would be education.
comes, excuse me, not energy. They've been in the news too, haven't they? Yeah. Education comes rolling down the track with that cross-examine reg that they're talking about doing, and you said how many? 110,000 comments?
110,000 plus.
What if they roll down the track before you get finished with us in this system? Has it been a waste of time for all of us because they're going to wash us out and say, nope, A&M, you got to amend your system, let them cross-examine?
No, Your Honor. Doe's hearing has concluded that finding has been made. There's nothing in the proposed rule that says that it applies backwards. And in fact, the proposed rule says we know that there's some...
You don't think it'll be retro is what you say?
No, Your Honor. And in fact, the proposed rule says, look, we know that there's some confusion about what the rules are going to be. So go look at this document that we posted. It's a Q&A about what to do now. And in that Q&A, it says expressly that that schools may continue to limit the participation of a student's representative in university disciplinary hearings. So the Department of Education has said what A&M is doing here is fine. It's hard to believe that it would say that if it was a due process violation.
Two questions I need to interrupt you to ask. One with regard to Carmody and similar cases. Was that a 12B6 federal motion?
Carmody was, Your Honor, yes.
Okay. Was the complaint that was raised in Carmody raised and ruled on prior to the conduct of the hearing?
Yes, Your Honor. The prior to the conduct of the hearing, the plaintiff there said, I want these procedures, and the university said no.
So it's not like the traditional preservation requirements that we think of as lawyers. The last speaker talked about thinking like a lawyer. It's a different type of preservation or waiver. It's not like the traditional.
Well, it's similar, Your Honor. If you were to think about it like that, Joe said, I want cross-examination. He objected, so he would have preserved that if he had attended. And so then he would say, okay, you asked for it, they said no, you went through the hearing, you developed a record so that we're actually able to look at what happened so that we can judge this. I mean, this is what happens in court. You object, it's overruled, you keep going, you build a record, you don't take your toys and go home. And
well, I mean, there's actually, in the criminal arena where we see this more often, a pretrial motion to suppress or something about evidence, we do see a previous ruling that preserves the complaint, whether the defendant stays for trial or not. It really wouldn't matter. He could be tried in absentia, or in civil cases, you get you try to get a case dismissed, and the one that comes to mind is a special appearance in civil cases. You go down and try your special appearance, and you lose, and so your lawyer tells you you've got two choices. You can either come to Texas and be tried, or engage in this lawsuit, or you can stay home, and then when we get up on appeal, we'll decide, or they will decide, whether or not you were actually susceptible to jurisdiction of the state of Texas, and you can skip the whole trial.
Your Honor, when you're dealing with the power of a court to hear a case, I think that's just a different category. And what the courts have over and over again told us in this context, even this court in whole said this, you don't allow someone to skip the process when all of this could have been avoided if they had gone through the process. And even if it couldn't have been avoided, this court would have a record. The Supreme Court in Bexar County, the Supreme Court in Fan, it looked at the record. It looked at what happened. And that's the only way. The court said, we can't do bright line rules. We have to take a case-by-case approach. We have to look at what happened.
And see, that to me, that feeds more into your third issue of showing the prejudice. But I need to get back to my other question. You referenced the Q&A in connection with the DOE review of rules. And this is what I'm struggling with on your second issue, and this Matthews versus Eldridge balancing. What is the source? I mean, because we're in appellate court, we're bound by a record. What is the source of the information? And I'm reluctant to use the word evidence in that context because it's not evidence in the traditional sense. But where do we find what it is we're supposed to and can properly put in this weighing analysis that we're called upon to use in Matthews?
Well, Matthews tells you, Your Honor. Matthews says substantial weight must be given to the good faith judgment of agency officials that the procedures they have required assure fair consideration of the issues. And then in Bexar County...
Where is that in my record? The good faith judgment of the officials?
Sure, Your Honor. The way that the court would do that is similar to a rational basis review. If a government puts forth an interest, puts forth a basis, the court will judge whether or not that is reasonable. And so in Bexar County, the Supreme Court said the government may reasonably conclude that post-termination confidentiality is necessary to ensure the unfettered testimony of the witnesses or to encourage future cooperation with government authorities. The court simply considers whether the interest that the government has put forward is reasonable. And it's important to note here that plaintiff does not dispute that encouraging the reporting of sexual misconduct is an important interest that is threatened if direct cross-examination is allowed. In fact, that is the basis of rape shield laws that limit the scope of cross-examination. And what the courts have done there is that that is a legitimate interest. And that interest was also noted by the Supreme Court in Bexar County, which has said that in sexual harassment cases, this is a particular concern that people will not report. And in just last term, the legislature passed a law designed to encourage reporting of sexual misconduct. There's not a debate here that is an important interest and that interest is threatened, just as there is not a debate that formalizing university disciplinary hearings will cost resources, will take away from the academic mission. These are all well accepted and undisputed interests.
But it's like you're asking us to take judicial notice of things that are outside our record, and we're making some type of policy analysis as opposed to deciding a disputed issue here.
No, Your Honor. Matthews requires courts to look at what the government interest is, and no court has ever required that a court bring in experts to testify about this. This is just like a rational basis review. The court can consider whether this interest is reasonable. And for rape shield laws, for example, no court ever required that the state of Texas or any other state bring in evidence saying that, oh, well, your interest, that your concern about the victims coming forward is actually present, that you accept the good faith judgment of the government. You presume, you start with a presumption that it's constitutional. And again, Your Honor, there's no dispute here. Plaintiff has not disputed any of these interests. And so you don't have to go outside the record. This is something that we have put forward as an interest, and the court simply considers whether that is a reasonable interest.
So go ahead.
The plea to the jurisdiction, the hearing on that was a non-evidentiary hearing.
Yes, Your Honor, it's a question of law. When you're considering state interests, it's a question of law.
And so there's not been any other evidentiary hearings in this particular case in the trial court.
Yes, Your Honor, and one of A&M's points is that because he did not participate in his hearing, he did not develop a record on how A&M's processes would
I'm talking about
work for him.
In this particular trial court case, not the administrative hearing, but in this trial court case, there's not been any other evidentiary hearings.
That's correct, Your Honor, because he has not pleaded a viable claim. In his complaint, he admits that he didn't attend his hearing. In his complaint is that this court must establish a categorical rule that in hearings like his, you must have attorney-led cross-examination. And every court to consider that has said no. And so this is a legal issue. This is simply, did he plead a viable claim? No facts will change any of that.
Anything else at this point?
No, not at this point.
Thank you. Then I will yield back the remainder of my opening time.
Oh, I gave you 3 more minutes. So
yeah, I saw that. So I'll give it right back. Thank you, Your Honor.
Oh, you heard that. And 2 other things.
They are.
You want to amend?
No. They are considered the same.
All right, on that part. But the other part is next on your pleading. You want to amend? You want to plead to the jurisdiction so far? You want to amend, and if you think about it as a viable option, then tell us why or why not.
Don't need to amend.
And all right, if you're on record now about that, that's good. You gave us a clear answer. In that last part that you just said, why aren't we, along with A&M, along with your client, supposed to be very worried about the balancing of these 3 women apparently alleged to be victims? I'm not talking about the Shield law right now. Our court gets to mess with the Shield law more than we want sometimes.
I know
you know about that.
Yes, sir.
But why shouldn't we be concerned when we try to figure out how to decide y'all's case on both sides about those women as well as your client?
Well, I think the university has done an admirable job of attempting to protect the victim. They have not done what we believe the law requires in order to protect John Doe. He has to remain unnamed at the present time simply because this is the federal rights of students not to have their names released. But, Your Honor, if I could first go to this issue of waiver, because that seems to be the knock it over the fence issue that my learned counsel on the opposite side wants to convince you of, is that we simply have waived any right to come in here and claim that we should get cross-examination. And he said that we needed a rule. I don't need a rule. What I need is for this court to follow the law. The Fifth Circuit has made this real crystal clear for us, and that was in Caprillion versus TW. We've cited this in our brief. They said, in that case, where the law is still under construction, the application of due process, and those standards are still developing. They said this was their quote, where such precious procedural rights are involved, we would be slow to divine a waiver of them, an intentional foregoing of a known right. We declined to find waiver here. Judge G wrote that. The present law is clearly in flux. You'll see in the brief, we wrote about Doe v. Baum. They wrote about Haydak out of the First Circuit, Doe v. Baum out of the Sixth Circuit. They cited a litany of state cases and other federal cases on one side and the other. I mean, this one issue may be going up to the Supreme Court, United States Supreme Court. It's clear that in this instance, we, just like in Caprillion, we came and told Texas A&M before the hearing. We didn't just not show up. Before the hearing, we wrote them and said, we need cross-examination. And they denied it. We appealed, and we went to the appellate hearing and wrote them and said, we need cross-examination. And they denied it. We did what we needed to do to preserve our claim for cross-examination, the greatest legal engine ever invented to discover the truth. Now, let's go to the balancing test. You're right.
I want to
Judge
stick
Davis.
with the first one for a little bit, counsel.
Yes, Judge Gray.
You said we need cross-examination. I need you to articulate, flesh out, ever how you want to explain it, why the indirect cross-examination that would have allowed you or your client to pose the question and it be asked by the administrator of the panel.
Well, you can look at CR, the court's record, and this would be the declaration of Jacqueline Upshur Brown, who is a program coordinator, and this tells you what they do. It says, under TAMU rules, an accused student can directly cross-examine all witnesses, except, in other words, they do it already in all other cases, except that the procedure is different when the respondent seeks to cross-examine a student complaining of sexual misconduct. That seems backwards to me, but that's their rule. In those cases, cross-examination is permitted by submitting written questions to the panel chair, who screens the questions for relevance. Now, if they'd stopped there, I think they would have been better, but they didn't. Generally, in sexual misconduct cases, any question concerning the parties' relationship and sexual behavior is permitted so long as it is relevant and not asked just to harass, embarrass, or humiliate the other party. Justice Gray, part of cross-examination, maybe it shouldn't harass, but it certainly can embarrass. These decisions being made by an administrator that you're handing questions to completely wreck the invention that John Henry Wigmore wrote about.
But see, we don't know that because we don't know that there was a single question posed by you or your client that was not asked.
And you wouldn't, because even if we had gone, that cold record would not show that, because that record doesn't show the questions that were proposed to be asked.
Why wouldn't it?
It only shows the questions that were asked, because those are not on the record. I've been there to those hearings.
We routinely, in criminal cases, have, and right now the word escapes me, a presentation of the questions that would have been asked. You make a bill. Thank you. It came to my mind. You make a bill on the questions that would have been asked, and if they don't want to answer those questions that would have been asked, then you're allowed to say what you think the answers to those questions would be. Why would that not have been sufficient in this context?
Because it's not a court of law, and they don't let you make that record. You can't make a bill.
Then why is it your objection about not making a bill instead of not getting to cross-examine? Because you were allowed, would have been allowed to submit written questions.
We would have been allowed to submit written questions, but they would have been screened, and they are screened heavily by that person to make sure that those questions were not going to embarrass them. That is not due process, and I can show you why that's not due process. Because you've got to go to the Matthews balancing test to understand why that can never be due process. If you look at the Matthews balancing test, you look at the plaintiff's interest, you look at the benefit of the procedure, and you look at the burden, those three areas. And Justice Neal, to your question concerning a record, I agree with counsel that there has been no evidentiary record other than what is considered to be our complaint. We had the Supreme Court found City of Houston versus Houston Municipal Employees, which is in our brief, at 549 Southwest 3rd, 566 in 2018, said this: we review a trial court's disposition of a party's plea to the jurisdiction de novo. In doing so, we consider the pleadings, factual assertions, and all relevant evidence in the record. Looking at the plaintiff's intent, pleadings are construed liberally in favor of the plaintiff to determine whether the facts alleged affirmatively demonstrate the court's jurisdiction to hear the matter. Let me give you some record cites for you to understand the particularity of a harm that was alleged that supports our claim. At CR 4, paragraph 8, we allege Texas A&M issued a decision finding Doe responsible for nearly every allegation levied against him and expelled him from Texas A&M. At CR 5, at paragraph 10, Texas A&M went forward and upheld Doe's expulsion from Texas A&M. Texas A&M also immediately banned Doe from returning to Texas A&M's campus. Remember, this happened just weeks before Doe was to graduate. We had to get a temporary restraining order to keep him in class so he could complete his classes, which we did. What is left is they will not confer on him a degree. CR 6 at paragraph 12, deprivation of his property and liberty interest in his status as a student in good standing, in his interest in his education, and in his interest in his reputation. CR 7 at paragraph 14. A lawsuit will not prevent the arbitrary and erroneous deprivation of Doe's right to continue his education this semester and complete his undergraduate degree. Further, the imminent harm will be irreparably damage Doe's reputation, causing him to suffer extreme stigma that will prevent his enjoyment of educational employment opportunities. All right, now, Judge Bryan, if you'll recall from reading the record, was quite clear as he announced his decision. This is what he wrote, this is what he said, rather, that was recorded. A&M taught me a code of honor. He was talking about himself, Judge Bryan. Judge Travis Bryan was a 1969 graduate of Texas A&M. He said, A&M taught me a code of honor that you do not lie, cheat, or steal. And we have an administration that's doing exactly that. Cheating and stealing away a person's reputation, their livelihood, their career path, and doing things that ultimately could lead to having to make admissions in a forum out there that would be used against them in a court of law, later to put them in prison and allow no right of cross-examination. Another particularized harm. Our response to him also contained additional pleadings about harm, including the loss of his job with Amazon that was waiting for him upon the award of his diploma. That was at CR 146 through 150. What I quoted you from what Judge Bryan had announced was that Reporter's Record 40, 17 through 25, and 41, 1 through 5. But let's go back to this balancing test, Justice Gray, that's so important, because I think A&M runs from this balancing test because as they run from it, they know they can't win this if we really look at this balancing test that is required by Matthews the Eldridge that you pointed out. We have what Judge Bryan said concerning the plaintiff's interest. We have...
How do we weigh in Judge Bryan's comments? Is he now a provider of evidence?
You may consider under City of Houston versus Houston Municipal Employees his comments that we have demonstrated particularized harm. Yes, you can, because they said you can consider all those issues. Also, look at the letter that was sent my client, Mr. Doe, in August of this year that was attached as Exhibit A and B to a letter that was emailed to him concerning a threat that they were going to give out information against him. Our letter that I provided you on November the 11th in letter brief. They wrote, my client FERPA permits disclosing the final results of any disciplinary proceeding conducted by such institution against a student who is an alleged perpetrator of a crime of violence or a non-forcible sex offense. Texas A&M University has identified your student conduct record to be responsive to this request, and we're going to release it. Mr. Brown out there then wrote a follow-up letter in Exhibit B. He's an assistant general counsel that said FERPA only permits the release of final results of disciplinary proceedings, and because you have this current civil lawsuit, then we're not going to release it now because of this lawsuit. But if you should grant their plea to jurisdiction, they can report this.
Are you at, what level are you now? Are you still with a TRO that's been extended, or do you actually have a temporary injunction?
What happened was we got a TRO. It was dissolved after he finished his classes, and then we had our plea to the jurisdiction hearing, and the plea to the jurisdiction hearing resulted in our favor. That's why we're appellee, and then the state of Texas was able to take an interlocutory appeal, and that's why we're here.
Okay, so your case is that the potential of a hearing, a hearing
Absolutely.
To support a temporary injunction.
Absolutely.
Okay, let me ask you then. Seems like when you got to finish his classes, in essence, that partially mooted your case because he got to finish. Stay with me a minute. Stay with me a minute. But he didn't get the degree, and so that's still a big issue. Can this court take Matthews as its lead horse case and everything that's followed since? Look at what ought to be balanced and send y'all back, whether you either one agree with it or not. I didn't say that. And send you back for an evidentiary hearing in front of Judge Bryan before we look at it further.
You know, Judge Davis, I've known you a long time. You can do whatever you want to do.
About 46 years.
Yes, sir. And if that's what you want to do, that's fine.
I don't know that we have authority to do that.
I think you do. What we ultimately want you to do is to uphold Judge Bryan's ruling because in Doe v. Baum and my learned counsel on the opposing side said no court has ever decided this. Well, he's wrong about that.
Well, he actually said, and I'm putting words in his mouth, yes. Sorry about that. Actually, one thing y'all seem to agree on today is Matthews might be a good starting point for us.
Matthews is a good starting and finishing point for you because Doe v. Baum says this. Today, we reiterate the holding once again, citing to University of Cincinnati. If a public university has to choose between competing narratives to resolve a case, the university must give the accused student or his agent an opportunity to cross-examine the accuser and adverse witnesses in the presence of a neutral fact finder. What we want is to use what Professor Wigmore told us was the greatest invention, legal invention ever done, and that is to discover the truth. I'm out of time.
But in Baum, they did not discuss the nature of the cross-examination, direct, indirect, what you characterize as adverse.
No, Your Honor, but what I did was I wrote you in another letter brief about a case in which the ACLU has jumped in with the University of Michigan. And may I go ahead and answer your question?
Please do.
All right. And I provided you that ACLU letter where they're saying, no, you've got to have this greatest legal invention ever made to discover the truth, and that's cross-examination.
And then I jump back to a previous comment. You were talking about the Open Records Act request and that gets back to my whole problem about that there was no evidentiary hearing, but now you're asking us to consider not only evidence, but events that occurred after Judge Bryan made his ruling, and I'm questioning how we can do that.
And what I would do is I would send you to that Houston case that allows you to consider all of these issues for the particularized harm. That City of Houston versus Houston Municipal Employees, 2018 Supreme Court case. It's 549 Southwest 3rd, 566. The Matthews balancing test, I know it's kind of hard not to get hung up on what evidence do we look at, but it's clear they said they look at it de novo, and we consider the pleadings, factual assertions, and all relevant evidence in the record. So you have more than the evidence to look at.
But there is no evidence in this record. There's been no evidentiary hearing, so all we've got is your pleadings.
Then you look at your pleadings and any factual assertions. We believe there's plenty there.
And if as the chief suggests, that we were able to craft a solution that's within appropriate standards for you guys, I'm troubled as he is, and I know Judge Neal is, about release of information. Okay?
Yes, sir.
All right. And how would we go about that? I mean, let's face it. They've given you their written word. I read everything. I read past midnight. You're still sending me stuff. So were you. Before I came over here. How do we craft that other problem, which is keeping both of you under significant pressure for your clients, by your clients, to where release of information doesn't happen while this appeal is going forward? Do you have enough room under your temporary injunction pleadings? I haven't looked at it for that purpose.
Yes, I think we do, Your Honor.
Okay, well, he may or may not agree with you, so you get to talk to us about that in a minute. Is that the way we craft it, or ask Judge Bryant to look at it?
You also, we have to work within FERPA, the law that protects students, federal law that protects students' identities. That's why our lawsuit is styled under John Doe. Okay. And we can continue forward. All we need this court to do is say, affirm Judge Bryan, then we go back to Texas A&M. We get a proper, appropriate hearing with cross-examination that Professor Rigmore would be proud of you and me too for doing. Thank you, Your Honor.
Okay.
Anything else for him? Okay.
You going to help us here?
I'm going to try, Your Honor.
Appreciate it.
May it please the court. Your Honor, that was 20 plus minutes of a claim that is not before this court. They have asked for attorney-led cross-examination in disciplinary hearings. He didn't say anything about it because he's running away from his claim, because every single court, he talks about Caprelli and he talks about the law in flux. There's no law in flux. Every single court that has considered this question has said no. Doe v. Baum didn't say it. No court has ever said this. He is asking for a rule that is extreme, that even when there are criminal charges pending, courts have said the attorney can be there. That's what A&M allows. But the attorney may not participate, because if the attorney participates, the other side is going to get an attorney, the school is going to get an attorney, and it turns it into a trial. And the Supreme Court in Than said that is what you do not do. You do not formalize these procedures and turn them into a trial.
Can we use Matthews or not?
Yes, Your Honor. We don't run away from Matthews. Matthews.
I didn't think you did.
No, he says we have, we rely on waiver as our slam dunk. All three are slam dunks. Waiver, Matthews, prejudice. He clearly loses on all of them. And if I could talk about Wigmore, cross-examination was allowed here. This is what the court in Fury v. Temple said. The court concludes that due process required that the plaintiff be able to cross-examine witnesses. That the ability to pose questions through the chair gave the plaintiff the opportunity to raise questions through cross-examination. He quoted Doe v. Baum, which cited the opportunity for cross in Doe v. Cincinnati. That was intermediate cross-examination. Exactly what A&M provides. So Doe v. Baum supports us. Doe v. Cincinnati supports us. Hydak from the First Circuit supports us. Sabetti was almost the exact same claim that we have here. The district court there said procedural due process requires cross-examination by counsel, and the court said, actually, the first court said procedural due process requires nothing for attorneys to do in a hearing, and that indirect cross-examination was fine.
In all of the cases you're referring to, was the intermediary an employee of the university that was the subject?
Yes, Your Honor, and this is a neutral intermediary. This is not a fact finder. This is not somebody that is on someone's side. And in fact,
I think that would be disputed whether that individual was neutral or not. I mean,
no, Your Honor, it's not. In their briefing, he can laugh. In their briefing, they say, well, the problem here is that they consider both sides. That's what a judge does. The judge considers both parties, and in fact, counsel complains that embarrassing questions will be kept out. Texas Rule of Evidence 611 says the court should exercise reasonable control to protect witnesses from harassment and undue embarrassment. There is nothing weird about what A&M does, and as we have explained, and as Doe's counsel does not dispute, everything that Wigmore says about why cross-examination is important comes through with indirect cross-examination. The one thing that he complains about is that he won't be able to embarrass a witness, but that's the same under the Texas Rules of Evidence. If I could turn quickly to the weighing of interest and whether you need facts, the Texas Supreme Court's decision in Andrade was a plea to the jurisdiction based on a complaint, and the court weighed interests, weighed the government interest, weighed the plaintiff's interest, and did so on the complaint on a plea to the jurisdiction, and said, as a matter of law, these asserted government interests prevail.
What was that case?
That is Andrade, the NAACP of Austin, 345 SW 3D 1. Counsel talked about stigma. He identified the problem. That Doe's interest here is, he's not going to be able to finish school. He's not going to be able to get the job he wants. He might not be able to enroll in another school. The exact same interest is present in every other case. Whenever you are expelled for misconduct, that's going to happen. And in every other case, the courts have said, not only is there no requirement for attorney-led cross-examination, but every court to look at indirect cross-examination said that it satisfies due process. Again, he cites Caprellian saying that there's something unsettled in the law here, and yet he's unable to identify a single case that is in his favor.
Jump to notification, will you please, because 2 or 3 of your last letter briefs between you got concerned about notification or release of information.
Yes.
Where are you going to be? Are you consistent with that position in print that you've taken with us?
Your Honor, according to the letters
Yes.
that he cited to this court, A&M has said they're not going to release the information. I have no reason to dispute that. But again, we explained how that's still not a stigma-based injury, and how even if it is, it's no different than any other case in which the courts have held, as we're asking the court to hold here.
Is along the lines of what Judge Neal was asking about just a minute ago, does A&M, is this the only procedure that has elements of an ADR claim to it? Or the other way to ask it is, does A&M have any other arbitration or mediation procedure that could be elected in this case if we ship the case there?
No, Your Honor. The disciplinary hearing has finished. They have found him responsible. They have issued the sanction of expulsion. The only thing stopping that is the incorrect decision of the district court here. And if I could just correct one more factual misstatement by
all I'm going to say is,
here.
I know you might not agree with it, but think about the idea of mediation of this case. Now go forward with what you're going to say.
Your Honor said that the record, or sorry, the counsel said that the record in this case would not include the posed questions, but he has no basis to say that. And in fact, he could simply allege in his complaint the questions that he asked that weren't posed. And so I don't understand his argument that any posed questions that weren't asked wouldn't be able to be reviewed in this record. And I would simply finish by saying that all we're asking.
You're not through yet.
Oh, sorry. Of course.
Is anywhere in the record a full copy of the procedures used by Texas A&M in their disciplinary proceedings?
Your Honor, we cited various rules about the hearings. We also cited there's an affidavit that sets forth the procedures. None of that has been disputed, so that the court can look to that if it wants. But really, the court can stop at the complaint. He's asking for attorney-led cross-examination, which no court has ever allowed.
You made a reference to a case before you said it was quoted in Doe versus Baum. Was it Fro or Fra?
Sorry, Doe v. the University of Cincinnati. This is in the kind of summary paragraph of Doe. It says, all we're doing is reaffirming what we said in Doe v. University of Cincinnati. And Doe v. University of Cincinnati said the interests involved here justify indirect cross-examination.
Doe versus University of Cincinnati in the table of contents. Chief's trying to get it, and I am too, but is it 872 Federal 3rd 393? Do you have it in front of you?
Got it.
I think it's there.
Yeah.
Page 13.
Got it.
The mediation idea is what it just simply strikes me. I'm not sure this is a case that fits mediation, to tell you the truth. But I also want you to, as you drive home, think about it.
Thank you, Your Honor.
All I ask of you is to do that.
And you
on
were,
behalf of me and my colleagues.
You were about to try to settle up summary. You may proceed.
Simply that all we're asking this court to do is apply well-established rules and do what every other court has done, and to reverse the district court and render judgment dismissing Doe's claim. Thank you.
Thank you, counsel. This case is submitted. Y'all are excused. We will adjourn back to Waco, in which we'll write these cases up that y'all have heard argued today. And we appreciate your time, your attention, staying with us on this third case, though it was delayed. And with that, good day. Thank you.
Thank you, folks.